My dear students who are aspiring judge post is required to follow some techniques. Then only it is easy to crack the JCJ prelims mains vivos. So this is a very competitive exam. One needs to do more hard work with commitment, dedication, determination. Dear students, I can say it is not easy, but at the same time, it is not difficult. The only thing is, one is required to study with determination by adopting some techniques. Then you may feel it is convenient for you to go forward. I, Dr.Anjaneyulu, Vijayawada, starting JCJ prelims coaching. My institute name, Anjaneyulu Law Institute, Vijayawada. Classes only online. Now I am going to give how to read BEAR Act. I feel with my experience, the studying BEAR Act is very vital role for all legal fraternity, especially JCJ aspirants. So everybody will read answer. Getting 60 marks out of 100, the hard worker can succeed. But between 60 and 80, the student is required to read in a different manner. The winner always do the things differently, not different things. So in this video, I am making an attempt to give some techniques how to read BEAR Act, how to understand the illustrations, intrinsic value of the BEAR Act. Let us start. First, I take the Indian Contract Act. Then we have to see the title very carefully. The definite article, why they used Indian, that means it was passed by the British Parliament. That is a contract. Act means legislation. In the year 1872, it goes without saying that this legislation is brought by the British Parliament. Now the question before us is, మరి మరలా మనం ఎందుకు దీన్ని కంటిన్యూషన్ లో ఉంచాము? ఇది బ్రిటిష్ పార్లమెంట్ తీసుకొచ్చింది కదా. దెన్ వన్ నీడ్స్ టు నో కాన్స్టిట్యూషనల్ లా. ఇన్ ఇండియా, కాన్స్టిట్యూషనల్ లా ఇస్ ద సుప్రీం లా ఆఫ్ ది ల్యాండ్, fundamental law of the land. Then every law should agree with the constitutional law. Otherwise, that law is invalid to the extent of its inconsistency with the constitutional law. మనం ఇండియన్ యాక్ట్ ని కంటిన్యూషన్ లో ఉంది అని మనం చెప్పడానికి, దెన్ ఆర్టికల్ 372 ఆర్టికల్ 372ని మనం కనుక పరిశీలించినట్లయితే, కంటిన్యూన్స్ ఇన్ ఫోర్స్ ఆఫ్ ది ఎగ్జిస్టింగ్ లాస్ అండ్ దేర్ అడాప్టేషన్, notwithstanding the repeal by this constitution of the enactments referred to in article 395, there the act 1935, 1947 were repealed, but subject to the other provisions of this constitution, all laws in force in the country of India immediately before the commencement of this constitution, 26th January 1950, shall continue in force. Therein, until altered or replaced or amended by competent legislature or any other competent authority. This Act 1872 was not repealed. Therefore, this Act continues in operation, continues in existence. So, this is further buttressed or supported by Article 13.2. Pre-constitutional law will be tested whether that pre-constitutional law is agreeing with the fundamental rights of the constitution or not. If the existing laws are not agreeing with the constitutional law with regard to the part 3rd of the constitution, to that extent that existing law is void. That is as per clause 1 of article 13. This contract act is not inconsistent with the fundamental rights of the constitution, therefore the act is valid. Then how to read the bare act? Then one is required to take much care with regard to title. Title of the act is also important. One needs to look into the title because in interpretation, the title preamble will play a vital role. Then this will available in section 1. Extent. Then we have to see the operation of the act extent. The whole of India. Now the Jammu and Kashmir has no value. That means that state was derecognized. Therefore, then extent has to be looked into. The very important thing in section 1 is commencement of the act. When the act does come into force is very important. Below the title of the act, there is a date, that is enacted date. But section 1, we can see the commencement. When does the act comes into operation? Therefore, the government has to give notification with regard to the commencement of the act. So, Parliament or the legislature makes the legislation. Then the executive has to put it in operation. That is why this is known as a conditional legislation. There are several legislations where they were not brought into operation by the government. With regard to the Contract Act మనం తీసుకున్నట్లయితే, for the convenience of the student, I divided the Contract Act in 4 parts. Part 1, general principles. Part 2, repealed Sale of Goods Act. Part 3, specific contracts or named contracts. Part 4, repealed partnership. The Contract Act contains from section 1 to section 266. 1 to 75 sections dealing with the general principles. From 76 to 123, earlier relating to sale of goods. Now, this area was repealed, deleted, and brought a separate legislation, Sale of Goods Act 1930. With regard to the part 3rd, from sections 124 to 238, dealing with the specific contracts or for our convenient named contracts. From 239 to 266, earlier dealt partnership, now it was repealed and the Partnership Act 1932 was brought. With regard to the general principles, there are 6 chapters. Preliminary, sections 1 to, then communication, acceptance, revocation from 3 to 9 sections. Then contract void agreements, that is from 10 to 30 sections, that is chapter 1, chapter 2. Chapter 3, contingent contracts, 31 sections to 36. Then performance of the contract, 37 to 67. Then quasi-contract, 68 to 72. Then remedies, 73 to 75. From 1 to 75, there are 6 chapters. It is easy to remember PCQ, PQR. PCQ, PQR. 6 chapters plus preliminary. With regard to the specific contracts or named contracts from 124 to 238, we can make it simple for remembering purpose. That is IGBPA, indemnity 124, guarantee 126, bailment 148, pledge 172, agent 182. Contract 1 general principles. Like a human being. Every human being is having normal characters. Contract 2 or specific contract is concerned, that is a named human being, in the sense that he is having all the characters of the human being. Because of his name, he is having some more characters. That means in contract of indemnity, guarantee, bailment, pledge, agency, that possess all the essentials of the contract and additional characters basing on its name. Therefore, it is easy to remember the specific contracts as IGBP Anjaneyulu. IG, Inspector General, BP Anjaneyulu. That is the contract 1, we will call it general principles. Contract 2, we will call it named contracts or specific contracts. Then we see the saving provisions. It is very, very important to look into the expressions like saving, repeal, etc. This Act 1872 saved the other provisions of the legislations. When we read the wording of this saving, nothing herein contained shall affect the provisions of any statute, act, regulation not hereby expressly repealed, nor any usage or custom of trade, nor any incident of any contract not inconsistent with the provisions of this Act. How to read this? Nothing means not anything. Then we have to bring it here, not. Then we will remember very easily. The provisions contained in this Act shall not affect the other legislations which require writing, registration, etc. unless they are repealed. So that means this Act saved the other provisions of the statute with regard to the requirements. Then the next is that section 2, almost all in every legislation, there may be exceptions. ఎక్కువ లెజిస్లేషన్స్లో సెక్షన్ 2 డెఫినేషన్స్ ఉంటుంది. దాన్నే ఇంటర్ప్రిటేటివ్ క్లాజ్ అంటాం. కొన్ని స్టాట్యూట్స్లో డెఫినేషన్ అని రాస్తారు. ది వర్డ్స్ యూజ్డ్ ఇన్ ది స్టాట్యూట్స్ ఆర్ డిఫైన్డ్. in every definition there is an expression, that is, unless contrary intention appears from the context or unless the context otherwise requires. This is very, very important. What does it mean? You follow the meaning of the words used in the statute as given in the definitions. Suppose at a particular context that meaning is not suitable, you take a different meaning. Sometimes we have to take straight means this one. Sometimes we have to take means a dead end road. This is also called as straight. The context requires that here. Straight always does not mean like iron rod. It may be dead end road. That is hill road can also be considered as straight. That is the context. So that is why the context should not be ignored for applying the meaning. The other important thing I feel, the definition starts with the meaning, includes, excludes, or 2 or 3 or 1. If the definition starts with the expression meaning, the definition is exhaustive. We have to confine within the box. We should not go outside. We have to confine within the meaning of the definition, because the definition starts with the meaning. That is exhaustive. If the definition contains includes, that is an extensive, then we can go out of the box also. We can go out of the box also. When the definition used, we can go out of the box. We can go out of the box. Need not confine to the box. Similarly, excludes. If some things are excluded, the non-excluded items are deemed to be included. So therefore, while interpreting the definition, one should look into the starting expression, whether it means again at the end it contains includes or excludes. Then only one is able to write correct answer, that is multiple choice question. This is very, very important who is preparing for JCJ. We may get bits in include part, exclude part, illustration part, explanation part, proso part. That is very, very important. One should take care of it. Then we'll see the definitions of the contract type. It is also easy to remember. P car VC V Venkat. P car PQ car Vice Chancellor V Venkat. Proposal, promise or acceptance, promise or promisee, consolidation, agreement, reciprocal promises, void agreements, contract, voidable contract, void contract. So this is the easy way to remember the definitions. Then within the definition also, it is easy. Though the term agreement appears so simple, but remembering sometimes it may be some difficult. It is also easy to remember the definition of agreement EP ESP. EP ESP. Every promise and every set of promises forming the consent for each other is known as an agreement. Like reciprocal promise also, it is easy to remember PWF. Promises which forming the consideration of the part of the consent for each other are known as reciprocal promises. So there are techniques to remember definitions. P card Vice Chancellor V Venkat. Then the most important definition in contract section 2D. My dear students, you see this section. When yet the desire of the promisor, that is within the commas, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or to abstain from doing something, such act, abstains, promise is called a consideration for the promise. A consideration for the promise. Then you see the son purchased cell phone. The son purchased cell phone. Here the seller is offering to sell the cell phone. The seller offered to sell the cell phone. The son wants to buy it. Father paid the amount. Here the consideration moved from other than the promisee. That is privity of consideration. When at the desire of the promisor, seller, the promisee buyer or any other person, his father, may pay the consideration. Of course, consideration may be past, present, future, but there must be a consideration. Therefore, the consideration need not be between the previous parties. It may come from third party. The privity of consideration is allowed. The famous case with regard to privity of consideration, Chinnaya versus Ramaya. In fact, this is wrongly printed, Chinnamma versus Ramaya. But we have to follow this Chinnaya versus Ramaya, exactly Chinnamma versus Ramaya, that is the correct case. But print mistake, but it is continued. Then, with regard to the contract general principles, we can make it convenient. You see, proposal, acceptance, the result is agreement, plus enforceability, that becomes contract. Then performance, discharge, breach, remedies. So that is easy to remember. Proposal acceptance is equal to agreement, plus enforceability is equal to contract. Next step, performance. If it is performed, it is discharged. In case of breach, remedies. So my dear JCJ aspirants, you should see all contracts are agreements, but all agreements are not contracts. You see, when we take the contract 100, definitely agreement is 90 or short of 100. Short of 100. When we add 10 to 90, we will get contract. When we take 90 as agreement and we should add 10, that is enforceability. 90 plus 10 is equal to 100. Then this is contract. That is why all contracts are agreements. That means within 100, 90 is there. But 90 is not sufficient to treat it as 100. That is why all contracts are agreements, but all agreements are not contracts. So what are the essentials? You see, in contract, that is individual rights. In contracts, rights are right in rem. Therefore, there is a contract between two. In order to treat this contract as valid, then what are the essentials of the valid contract? This is also easy to remember. PA Paul LCM NCP. That is a proposal, then acceptance, free consent, lawful object, legal relationship, lawful consideration, capacity of the parties, mutual consent, not hereby expressly declared to be void, certainty, possibility of the performance. These are the essentials of a valid contract. That is proposal, acceptance, free consent, lawful object, legal relationship, lawful consideration, capacity of the parties, M. Satyanarayana. Major, sound mind, not disqualified. This is a cluster clear under section 11. Section 11 లో capacity of the parties ఉంది. Major, sound mind, not disqualified, is competent to enter into contract. The mutual consent, that is conscious adhesion, meeting of minds, not declared to be void, certainty, possibility of the performance. So if these are present, that contract is known as a valid contract. That means this is agreement plus enforcement. My dear students, section 10 is very, very important. What agreements are contracts? You see the starting words. All agreements are contracts. That is wrong. In such case, definitely after these words we see provided subject to if clauses that we have to observe. If this is true, if the following conditions are satisfied. We can't put full stop here. That goes wrong. If all agreements are contracts, if the agreements are made by FCLON, free consent of the parties, competent to contract for lawful object and are not declared to be void. Then section 10 also contains a second paragraph, that is, other acts will be saved if they are not inconsistent with the provisions of the Contract Act 1870. Contract Act 1870. My dear students, you see void agreement, that is simple, not enforceable. Valid contract agreements are enforceable. Voidable contract, CUFM. If consent of one of the parties is obtained by CUFM, coercion, uninfluence, fraud, misrepresentation, mistake, for mistake there is a different treatment. For CUFM, such contract is voidable. It is basically contract voidable at the option of one or others but not the others. Whose consent is obtained by CUFM, at his discretion he may avoid it. Until he avoids it, becomes valid. Then if he proves that his consent is obtained by coercion, uninfluence, fraud, misrepresentation, can avoid it. If consent is obtained by mistake, then treatment will be different. Either it should be valid or void, as per sections 20, 21, 22. Then the void contract, void ab initio. There is a difference between void contract, void ab initio. Void contract means it is valid for some time. Suppose here the contract is formed here for some days, some months, sometime it continues. But at one point of time, it ceases to be enforceable. At that point of time, it becomes void. So A and B agreed to marry in January. They entered an agreement to marry in January. They fixed a date in March for marriage, but in February one died. That contract becomes void. void ab initio. You see, void ab initio what? Not contract. Not contract. So there is no question of formation of contract. Void ab initio means minor agreements are void ab initio. Here at the agreement stage, it becomes void. Therefore, void ab initio. Minor agreements are void ab initio. The other aspects in contract one: mistake, frustration, force majeure, that is act of God. Where the performance is not possible at the beginning, that is void as per mistake. At the formation stage, it becomes impossible, that is void. So formation stage is possible. Subsequent supervenity or the happening of something, the performance becomes impossible. Contract is discharged by frustration 56. Therefore, mistake and frustration both are mutually exclusive. Force majeure are the act of God, where the human agency has nothing to do with it. Then the performance becomes impossible due to the act of God. Then the contract is discharged. That may be covered in some occasions 56, in some occasions section 13. So both the frustration, force majeure are exclusive. Sometimes there may be intersecting. There may be gray area whether the contract is discharged by frustration or force majeure. So that is the other thing which we have to see is section 64, 65. Where the contract is voidable, that is a consequence of rescission of the voidable contract as a result of cuff M. Coercion and influence, fraud or misrepresentation. Who avoided the contract should return such a benefit received from the other party. My dear students, if you observe carefully, you do not find compensation here. Only the benefit received should be returned. Similar benefit should be returned. But you see, section 65, when the contract becomes void, then not only restore the benefit received or to make the compensation for it. Then we have to carefully observe this type of words. Otherwise, one may fail to put correct answer to the multiple choice question. That the compensation is what there in section 65. In every law, there will be maxims. Sometimes we can expect multiple choice questions. That maxim is dealt under so-and-so section or connected to the famous case. Void ab initio, section 11, capacity of the parties, Morbi versus Dharmodas. Privity of consideration, section 2D, consideration may move from any person, Chennaya versus Ramaya. Privity of the contract, stranger to the contract cannot sue. That is the common law principle. We cannot say particular section. There may be exceptions where the beneficiary can sue. The common law principle, privity of contract applied by the court in Dunlop Pneumatic Tire Company Limited versus Self-Regent Company. Quantum merit as much as earned, that is section 65, void. 70, non-gratified quasi-contract, the famous case with regard to the quantum merit by the Supreme Court. Alopi, Parshad and Sons Limited versus Union of India. Clayton's rule, that is dealt in section 59, where there are two or more debts, then the debtor paid the amount, he did not specify the which debt to be discharged by this payment. The payment is not sufficient to discharge completely any one of the debts. In such case, Clayton's rules will be followed. Then that payment will be credited or will be used for clearing the earliest debt. Similarly, my dear students, we have to see the landmark cases in this subject, because in 100 marks, previous question papers, we see 5 to 6 case laws. Who will answer at least 50% of the case laws, his success rate is more high. So therefore, one will answer the difficult multiple choice questions, then sure you will crack the prelims very successfully without waiting even for results also. So, my dear students, there may be several techniques. These are the simple techniques, because I have been following for the last 34 years. So it is easy to remember any subject provided if we follow the coding system. So I suggest you, either on your own or with the assistance of the other institutions, prepare well with determination, dedication, commitment. So that means your eye always on judge post. Your eye should always on judge post. Juice pens is the eye of law, then judge post is the eye of you. So therefore, I guide you, I suggest you, it is not difficult, but at the same time it is not easy, but the post is very, very valuable post. So basing on that, one wants it, you should commit to achieve it. So I wish you the good luck. Thank you.